This is immigration attorney Parviz Malakouti. In this video, we're going to talk about whether freelance work counts as unlawful employment if you're in the United States but you do not have a work permit. This is a super common issue that's coming up now, especially as we're moving towards a more remote economy. A lot of people are not having the traditional employer-employment relationship. They're doing freelance work, social media branding deals, all kinds of different things. I recently had this situation come up in one of my cases. I had a client. She was doing modeling work on a very popular, well-known modeling site. I'm not going to name the site, but if you are on social media, you definitely have heard of this, even if you're not using this particular site. She was doing modeling work on that site. And when we submitted the green card application, the application for adjustment of status, she didn't disclose to me as her attorney that she was working, even though we asked about it. And she didn't actually bring this up later, We only found out right before we were about to go to the interview, to the green card interview, for adjustment of status. Why didn't she disclose it? Because she thought that doesn't count as employment, for the purposes of USCIS, because it was freelance work done with a company, a social media company, modeling work, and that company was based outside of the United States. It's based in England, She thought that doesn't count. She was wrong, Luckily, we were able to catch that issue and report that to USCIS at the interview that she was actually employed. And in this instance, because she was married to a US citizen, she was what's called an immediate relative, which means that the consequences of having worked illegally without authorization in the United States were alleviated, Basically, were not something that's kept her from getting the green card because there was a waiver for that, Now, that's a complicated situation. I don't recommend, if you're not an immigration lawyer, that you try to figure that out for yourself. If you're applying for a green card, if you want to apply for a green card and if you worked in the United States without authorization beforehand, you definitely want to at least have a consultation with an immigration attorney to see whether that's going to be a big issue for you when you apply for a green card and whether it's something that needs to be addressed with an attorney, whether it be with a waiver of inadmissibility or otherwise, But the bottom line is, if you're working, if you're doing freelance work, social media branding, YouTube, whatever it is, and you're in the United States without an employment authorization, that's unlawful employment for the purposes of USCIS. Don't get yourself into more trouble by writing no, by checking no to that, and then being charged with what's called a material misrepresentation, which basically means you lied to USCIS, and then you end up in even more trouble, So that's it for this quick video. If you have any general questions, throw them in the comment section below. If you have questions about your particular situation, click on the link below, book a paid consultation. We'll sit down 45 minutes on Zoom or telephone, you and I, and go over the details of your particular situation and what can be done to help your situation, if anything. So that's it. Good luck.